The story of Donald Trump's vast real estate empire, a collection of gleaming towers and sprawling golf courses, has always been inseparable from his public identity. For a moment, it seemed as if the very foundations of that empire were about to be seized, piece by piece, by the state of New York. The specter of law enforcement officers placing liens on Trump Tower, the gilded symbol of his rise, was a stunning prospect. This followed a monumental civil fraud judgment that threatened to dismantle the Trump Organization with a penalty that, with interest, climbed past $500 million. The narrative seemed set, a powerful figure, finally held to account, facing the tangible consequences of a decade of alleged financial deception. The clock was ticking down to a moment of unprecedented legal reckoning. But then, in a dramatic turn that sent shockwaves through the legal and political worlds, the narrative was violently upended. On August 21, 2025, a New York appellate court delivered a stunning decision. While the judges affirmed the core finding that Donald Trump and his company were indeed liable for fraud, they did something extraordinary. They threw out the colossal financial penalty. The court deemed the nearly $500 million judgment an excessive fine, a violation of the Eighth Amendment. The immediate threat of asset seizure, the dramatic scenario of Letitia James padlocking the doors of 40 Wall Street, evaporated in an instant. The legal earthquake had struck, and the ground beneath everyone's feet had shifted once more. For Donald Trump, who by this point was 7 months into his second term as President of the United States, the ruling was declared a total victory. His legal team celebrated it as a resounding vindication, reinforcing their long-held argument that the entire case was nothing more than a politically motivated witch hunt. It was a moment of profound relief for an empire that had been teetering on the brink of financial catastrophe. The decision effectively paused the most severe consequences of the original verdict, transforming a seemingly imminent financial collapse into a prolonged legal battle that would now escalate to the state's highest court. The story of accountability was far from over. It had just become infinitely more complicated. This reversal did not, however, erase the underlying facts of the case or the initial finding of liability. The court still agreed that fraud had occurred. New York Attorney General Letitia James immediately vowed to appeal the decision, signaling her determination to see the massive penalty reinstated. She framed the appellate court's decision as a partial victory, emphasizing that yet another court has ruled that the president violated the law. The legal roller coaster had just crested a new peak, leaving the public to wonder where the next terrifying drop would lead. The fundamental questions about justice, power, and accountability remained, but the immediate, tangible threat to Trump's properties had been, for now, miraculously averted. The journey to this legal precipice did not begin overnight. It was the culmination of a years-long, painstaking investigation, spearheaded by New York Attorney General Letitia James. Her office's inquiry was first sparked by public testimony from a key figure in Donald Trump's inner circle, his former personal attorney and fixer, Michael Cohen. During a 2019 congressional hearing, Cohen alleged that Trump routinely manipulated the value of his assets to suit his financial needs, inflating them to secure favorable loans from banks, and deflating them to reduce his tax burden. This explosive testimony provided the initial thread that James's investigators began to pull, unraveling a complex tapestry of financial statements and business dealings. Armed with this lead, the Attorney General's office launched a comprehensive civil investigation into the Trump Organization's practices. The probe demanded a mountain of documents, including years of financial records, internal appraisals, and communications between executives. The investigation was not a simple audit. It was a forensic examination of the very methods the company used to value its most iconic properties. Investigators meticulously compared the figures presented to lenders and insurance companies with the figures reported to tax authorities. What they began to uncover, they alleged, was a consistent and deliberate pattern of deception, a dual set of books designed to paint two very different pictures of the same real estate empire. The investigation faced significant resistance from the very beginning. The Trump Organization fought subpoenas, delayed document production, and publicly attacked the investigation as a politically motivated vendetta by a Democratic Attorney General. Donald Trump himself repeatedly dismissed James as a racist and her probe as an illegal and partisan effort to harm him and his family. Despite these headwinds, the Attorney General's office persisted, deposing key figures including Trump's children, Donald Jr., Eric, and Ivanka, and ultimately, Donald Trump himself. The legal skirmishes over testimony and evidence only served to lengthen the process. but they did not deter the investigators from their core mission. After 3 years of dogged investigation, Letitia James filed a sweeping 222-page lawsuit in September 2022. The lawsuit accused Donald Trump, his 3 eldest children, and the Trump Organization of engaging in a decade-long scheme involving more than 200 instances of false and misleading asset valuations. The suit sought not only a massive financial penalty, but also severe restrictions on the company's ability to do business in New York. It was a direct challenge to the business practices that had built the Trump brand. The long and arduous road of investigation had finally led to a courtroom, setting the stage for a legal battle of historic proportions that would test the limits of corporate accountability. The heart of the state's case against the Trump Organization was not just a general accusation of fraud, but a detailed list of specific and, according to prosecutors, flagrant examples of manipulated property values. These weren't minor accounting errors. They were wildly inflated numbers that seemed to exist in a world disconnected from reality. One of the most glaring examples cited was the valuation of Donald Trump's own penthouse apartment in Trump Tower. For years, his financial statements claimed the triplex was 30,000 square feet. Based on this exaggerated size, the property was valued as high as $327 million. In reality, the apartment is 10,996 square feet, less than half the stated size, a fact that drastically altered its actual market value. Another key example centered on Trump's Mar-a-Lago club in Palm Beach, Florida. The lawsuit alleged that Trump's financial statements valued the property as high as $739 million. This valuation was based on the premise that the historic estate could be sold and developed for unrestricted residential use. However, this completely ignored the reality of legal restrictions. Trump himself had signed deeds that severely limited any modifications to the property and explicitly restricted its use to that of a social club, not a private residence or a development site. Appraisers testified that, considering these restrictions, the club's actual value was a fraction of the number Trump's company presented to lenders, closer to the $20 million range. The pattern continued with the Seven Springs Estate, a 212-acre property in Westchester County, New York. Trump purchased the property for $7.5 million in 1995. By 2014, his financial statements listed its value at a staggering $291 million. This sky-high valuation was predicated on the imagined future profits from the development of 9 luxury homes on the property, a project that was never approved and faced significant local opposition. The state argued that valuing the property based on non-existent speculative development plans was a clear and intentional act of deception. It was another case of selling lenders on a fantasy to secure real-world financial benefits today. These inflated values were not just for bragging rights. They had a direct and tangible purpose. By presenting these exaggerated numbers to banks like Deutsche Bank, the Trump Organization was able to secure hundreds of millions of dollars in loans with more favorable interest rates than they otherwise would have received. The lenders, believing they were backing assets of immense value, extended credit under terms that were based on fraudulent information. The state argued that this created an unfair advantage in the marketplace and put the financial institutions at risk. It was a systematic strategy, repeated across a portfolio of properties, to leverage fantasy valuations for concrete financial gain. During the non-jury trial that unfolded in late 2023, the defense's arguments were met with pointed and often scathing responses from the presiding judge, Arthur Engoron. He grew visibly impatient with what he described as repetitive, irrelevant, and, honestly, nonsensical arguments. Trump's lawyers repeatedly contended that the valuations were subjective, that the banks had a responsibility to do their own due diligence, and that since the loans were ultimately paid back, there was no victim and therefore no harm. Judge Engoron systematically dismantled these arguments, both in his courtroom demeanor and, ultimately, in his final written decision, showing little tolerance for the defense's legal tactics. In his final ruling in February 2024, Judge Engoron did not mince words. He described the world inhabited by the defendants as a fantasy world that ignores reality. He accused Donald Trump and his executives of a complete lack of contrition and remorse that borders on pathological. He found their refusal to admit any error, despite the overwhelming evidence presented by the state, to be a compelling reason for the severe penalties he imposed. The judge wrote that the defendants' failure to respond to the questions truthfully, or at all, severely compromised their credibility. He essentially concluded that their testimony was not believable. One of the most striking aspects of the trial was Judge Engoron's rejection of the no harm, no foul defense. He stated unequivocally that the law does not require victims to lose money for a fraud to have been committed. The act of providing false information to secure a financial benefit is, in itself, illegal. He pointed out that the defendants had reaped hundreds of millions of dollars in ill-gotten gains through lower interest rates, benefits they would not have received had they been truthful. His ruling was a firm declaration that the integrity of the financial system itself was a victim, and that paying back a loan obtained through fraudulent means does not erase the initial crime. Ultimately, Judge Engoron's decision painted a picture of a company built on a foundation of lies, led by executives who believed they were above the rules that govern everyone else. He described their arguments as frivolous and a waste of the court's time. He noted that the case wasn't about a simple mistake or a difference of opinion in a complex valuation, but a persistent and intentional scheme to deceive. While the appellate court would later strike down the financial penalty he imposed, it upheld his core finding of liability. His detailed and damning assessment of the facts, and his description of the defendant's alternate reality, remains a central and undisputed part of the case's legal record. Before the appellate court's shocking reversal, the state of New York was on the verge of taking an unprecedented step, the seizure of Donald Trump's real estate assets. With the original judgment ballooning to over $500 million, and with Trump's lawyers stating it was a practical impossibility to secure a bond to cover that amount, the path was clearing for Attorney General Letitia James to begin enforcement. This process would have started with the filing of the judgment in the counties where Trump owned property, such as Manhattan and Westchester. This action would have automatically placed a lien on iconic buildings like Trump Tower, 40 Wall Street, and the Seven Springs Estate. A lien is not a physical seizure, but it is the critical first step. It acts as a legal claim against a property, preventing the owner from selling or refinancing it until the debt is paid. Had the judgment stood, the next step for the Attorney General's office would have been to ask a sheriff to execute the judgment. This could involve seizing liquid assets first, such as funds in bank accounts. If those were insufficient to cover the massive debt, the sheriff could then move to seize and auction off the physical properties themselves. The image of a for sale by sheriff sign being posted outside the gleaming, brass-adorned entrance of Trump Tower was a very real and looming possibility. The process of seizing a commercial property as complex as Trump Tower would have been a logistical nightmare. The building is not just one entity, it is a mix of commercial retail space, offices, and privately owned residential condominiums. The Trump Organization's ownership stake would have to be carefully untangled from the rights of the many other tenants and owners in the building. A seizure would have thrown businesses like the flagship Gucci store into legal chaos and created immense uncertainty for the residents of the luxury apartments. The process would have been mired in legal challenges, but it was a path the Attorney General was fully prepared to walk down. The August 2025 appellate decision to vacate the financial penalty brought this entire process to a screeching halt. With no monetary judgment to enforce, Letitia James lost the legal authority to place liens on or seize any of Trump's assets. The immediate crisis for the Trump Organization was averted. However, the specter of seizure has not vanished entirely. The Attorney General is appealing to the state's highest court to have the penalty reinstated. If she is successful, the threat of liens, seizures, and sheriff's auctions will return with a vengeance. The temporary reprieve has only postponed what could still become the most dramatic and tangible consequence of the fraud case. The civil fraud case brought by Letitia James does not exist in a vacuum. It represents the culmination of a long and well-documented history of questionable business practices, legal battles, and financial scandals that have defined Donald Trump's career long before he entered politics. From his early days in the New York real estate world, his business dealings were often characterized by aggressive tactics, mountains of debt, and a flair for exaggeration that frequently blurred the line between salesmanship and deception. This decades-long pattern provides crucial context for understanding the allegations of fraud that landed him in Judge Engoron's courtroom, suggesting a consistent methodology rather than an isolated incident. In the 1980s and 90s, Trump's casino empire in Atlantic City became a case study in leveraging debt and brand identity. His companies filed for corporate bankruptcy 6 times between 1991 and 2009. In these instances, he was able to use bankruptcy laws to shed enormous debts. often leaving lenders, contractors, and investors with significant losses, while he personally managed to protect his wealth and public image. Critics argued that he profited from these failures, using legal loopholes to escape the consequences of his high-risk financial strategies. This history demonstrates a comfort with using legal systems and financial maneuvering to shield himself from accountability and shift financial burdens onto others. Another parallel can be drawn from the saga of Trump University. In that case, former students filed lawsuits alleging the unaccredited real estate seminar program was a fraudulent enterprise that used high-pressure sales tactics and false promises of insider knowledge to sell expensive and ultimately worthless courses. They claimed it was not a real university, but a deceptive marketing scheme. After years of fighting the allegations and insisting he would never settle, Trump agreed to a $25 million settlement just after winning the 2016 presidential election. This episode highlighted a similar pattern, making grandiose claims to entice customers and then using legal firepower to fight accusations of deception. These past scandals, from the Atlantic City bankruptcies to the Trump University settlement, paint a consistent picture. They reveal a business philosophy that often prioritized perception over reality, embraced legal confrontation as a standard operating procedure, and displayed a willingness to make exaggerated claims for financial benefit. The New York fraud case, with its detailed allegations of inflated asset values, is not an outlier, but rather a direct extension of this long-established pattern of behavior. It is the same playbook, applied this time to financial statements for lenders, and it finally triggered a prosecutor willing to take the fight all the way through the court system. The New York civil fraud case, with all its dramatic twists and turns, has become more than just a legal dispute over property valuations. It has evolved into a profound test of a core principle of American democracy, the idea that no one is above the law. The initial massive judgment by Judge Engoron was seen by many as a powerful affirmation of this principle. It sent a clear message that even a former and current president could be held accountable in a court of law for corporate malfeasance. The sight of a powerful figure being subjected to the same rules that govern ordinary citizens was a potent symbol of a functioning justice system. However, the appellate court's decision to overturn the financial penalty, even while upholding the finding of fraud, has deeply complicated this narrative. For supporters of Donald Trump, the reversal was proof that the system could, eventually, correct for what they viewed as political persecution. They see it as a check on an overzealous prosecutor. For critics, the decision was a dispiriting blow to accountability, suggesting that for the wealthiest and most powerful, there can be liability without any meaningful consequence. It raises the troubling question: what does justice mean if a court can find you guilty of a decade of fraud, but you don't have to pay for the ill-gotten gains you received? The ultimate outcome of this case, which now rests with New York's highest court, will have significant long-term implications for Donald Trump's business empire. If the penalty is reinstated, it could trigger a genuine financial crisis for the Trump organization, potentially forcing the sale of cherished assets and fundamentally altering the company's structure. If the reversal is upheld, it would be a monumental legal and financial victory for Trump, allowing his business to continue largely unhindered, albeit with its reputation further tarnished by the confirmed finding of fraud. The future of the Trump brand and the family's wealth hangs precariously in this legal balance. Beyond the fate of one man and his company, this unfinished battle carries immense weight for the nation's faith in its own institutions. The case forces a confrontation with fundamental questions about fairness and power in America. Can the legal system effectively police the financial dealings of the ultra-powerful? Does accountability have teeth, or is it merely a symbolic declaration? As the legal proceedings continue to unfold under the shadow of a sitting president, the final verdict will reverberate far beyond the courthouses of New York. It will help define the relationship between power, wealth, and justice, shaping perceptions of American democracy for years to come.